Hello everyone. In this video we are going to be looking at the relationship between branches, specifically looking at the judiciary, and I'll be looking at the judiciary versus the legislature and the judiciary versus the executive in the same video because the ideas are similar and very much connected. The ideas that I'll be using today come from mainly from this book, and it kind of starts on about page kind of 219 and then kind of goes up to about kind of 230. If you're reading around the topics here. So this whole topic is about how each of the three elements of UK politics can check and balance on one another. Now let's just talk about those two terms together and separately. To check means to be able to prevent them from doing something that exceeds their powers or breaks the law or just does something that they shouldn't be doing. So to check means to actually kind of stop them from doing something. To balance means that actually maybe powers are shared out to stop one particular side becoming too powerful. Very similar ideas, which is why we often use the phrase checks and balances. We kind of merge them together. Now, in the past, we have looked more at this relationship here between the executive and legislature. So if I say to you something like the Prime Minister's majority in Parliament means that he can often dominate Parliament, that is talking about that relationship, and we're going to be looking more at that relationship in a bit more detail, probably in our next video. But we've already kind of talked about that relationship quite a lot, because it's one of the key themes in British politics, which is why this video is going to focus far more on the judiciary and how it interacts with the executive and the legislature. Some of what I'm going to say in this video we have kind of already covered, but hopefully it kind of puts it within context and will help you to understand it further. One point before we get started though is that a relationship is two ways. So my diagram here is slightly wrong because I'm implying here that the executive overrules the legislature overrules the judiciary, and the judiciary overrules the executive. If I could have found it, I would have found something that actually has arrows on both ends of each bit, because actually the checks go both ways. The executive has certain powers over the legislature and over the judiciary, and the judiciary has certain powers over the executive and over the legislature. So you can go clockwise and anti-clockwise around the circle simultaneously. So when we're looking at this, it isn't just that one can always override the other, it's to what extent they can both override one another, depending on what the topic actually is. So let's talk about Parliament versus the judiciary. So going back here, so that's going to be our green and yellow ideas together. Now this is arguably this is the weak chain in the link for the judiciary. The weak chain in the link? The weak link in the chain. There you go, that's the phrase. The weak link in the chain for the judiciary, because we have parliamentary sovereignty in our country. You might remember this term from right at the beginning of the course, but ultimately Parliament is in charge of our country. There are arguments to say we have a presidential style system now, and there are other bits of our system that are very, very important. But at the end of the day, constitutionally, Parliament sits at the top of the triangle. And ultimately, a vote in Parliament can overrule almost everything else if used in certain ways. Which means that the judiciary is a subordinate body to Parliament, and to an extent maybe the Prime Minister as well. But that's a more complex argument. And what this means is in effect that judges must enforce a law no matter how undesirable they find it. I.e., if Parliament makes a law, I'll just move myself to one side here. If Parliament makes a law, then the judges will have to put that into force in the legal system, even if they don't like it, because parliamentary sovereignty. Parliament's made a law, the judiciary is a subordinate body, that means they are kind of underneath them, and therefore they must obey. So this relationship is very slanted. Parliament is above the judiciary in almost every kind of status. If judges make a ruling, Parliament does not have to obey, but if Parliament makes a ruling, then the judiciary must. It is a lopsided relationship in this particular branch. They also, to take this idea a little bit more complexly, more complicated, they must also take into account what Parliament intended. So let's say there's a particular law that they're looking at and making a ruling over, they can actually go back and look at the original debates that took place in Parliament at that time to not just see what ended up written on the actual piece of paper that has the law on it, but to actually think, well, what was the original intention of this law? So it's always, what did Parliament think? What has Parliament written? What was intended by Parliament? It reinforces this idea that the judiciary is subordinate to Parliament in this way. Parliament can also overrule the judges by passing new laws. So let's say, for argument's sake, that there was a circumstance in which in which the judiciary did overrule a particular law, and that has happened. Parliament can then overrule that by creating a new law. So let's say that the current Prime Minister did something and the judges then kind of slapped him down. The Parliament can then make a law that now makes whatever was illegal now legal, i.e. they can change the law to mean that the judiciary is no longer a problem. And there's an example here. Oh, I've just skipped past loads of slides there by pressing the wrong button. Here we go. There's an example, and you saw this in the Judiciary documentary that I asked you to watch. The Terrorist Asset Freezing Act 2010. The Supreme Court ruled that the government... Oh, now I'm in the wrong one. Now I'm in the wrong place again. The Supreme Court ruled that the government did not have the power to freeze the bank assets of terrorist suspects. Gordon Brown didn't like this. He thought this was an important power that the government wanted, so he then sent the new law to the legislature. The legislature voted yes, and so a new law was passed in the same year to allow them to do it, i.e. the legislature disagreed with the Supreme Court's ruling, so they changed the law, and the Supreme Court then had to follow the new law. And again, it shows how straightforward it is in order for Parliament to overrule the judiciary. Of course, Parliament is not one person. We have to remember that. I've used this term Parliament as if Parliament can do this and Parliament can do that. Parliament is, of course, 650 MPs. That Parliament can only do something if there is a majority in Parliament to do it, and if after scrutiny and the committee system and whatever else, Parliament can only do something if as a group, collectively, they decide and vote for something to happen. But if they do, then the judiciary can do very little, if indeed anything, about it. Now, ECHR, what does this stand for? This stands for the European Convention on Human Rights, which is a document that basically lists a whole load of different rights that you and me have, and we discussed this in class recently. The UK signed the ECHR in 1998 through the Human Rights Act, and we then put that into UK law. So we kind of have a Bill of Rights in the UK as well, that says what a government can do and what a government can't do. But what then happens if a new law is made that conflicts with the Human Rights Act? So let's use an example that's actually quite topical. It's being debated at the moment. There is a law that's in part of the Human Rights Act. There's a bit that states how long a person can kind of work per week, and if they're entitled to sick pay and pregnancy leave and holiday pay and all those kind of things. And there has been some discussion about whether these rights should be changed in some way or adjusted in some way. So what would happen if the government then put up a new law that conflicted with the original rights on, let's say, sick pay in the Human Rights Act? Well, the answer is actually a little bit more is quite complex, because it's something called a declaration of incompatibility, which is quite weak. But let me talk about the US political system first, because I think when you look at the US political system, it's easier to then understand the difference with the UK system. So let's just go over to America for a minute. This is a slightly out-of-date picture, because Ruth Bader Ginsburg is still there looking at the US Supreme Court. Now, when the US Supreme Court makes a ruling, they use the Constitution. And you should be aware that the US Constitution is codified and it is entrenched, and that a constitutional law is different to a normal law in the American system. So there are laws which are in part of the Constitution, and there are just other laws. Now, if a law is made that conflicts with the Constitution, then the Supreme Court will come in and they will make a ruling that just destroys, or what we call strikes down that brand new law. Let me give you an example. Gun rights. So the state of Columbia, made a law to ban handguns in the 1970s, I think it was. And this was eventually challenged many years later in the Supreme Court. And the Supreme Court then said, well, Article 2 of the Bill of Rights, which is the Constitution, says that Americans have the right to bear arms. You might be aware of this particular rule of gun laws. And so they struck down the District of Columbia's gun laws rights, i.e. that law ceased to exist. That's very a powerful power by the US Supreme Court. They can literally remove a law that conflicts with the Constitution. And we can see this here. So on the left-hand side here, US Supreme Court can strike down unconstitutional laws. So what happens in the UK system? Well, the UK system at first glance is quite similar, because what the UK system can do is they can look at the Human Rights Act and they can look at the new law, whatever it might be, and they can also say, look, there is a problem here. There is something incompatible. One does not work with the other. But look at my hands. In the American system, we did this: constitutional law, non-constitutional law. But in the UK system, we have this. We have no higher and lower laws. We don't have a constitutional law and a non-constitutional law. We just have laws. So there is no way in our system for the Supreme Court to say that this law defeats this law. All the UK court can say is these are incompatible, i.e. they don't work together, which is why they make what's called a declaration of incompatibility. However, that does not strike down either of these laws. Both of these laws still exist. So what happens? It goes back to Parliament and the government has to kind of sort it out and decide what they want to do about it, or indeed do nothing about it, which is also the government's choice. Now, in reality, the government normally does take on their advice and does do something about it. And I should probably find some examples of when they had, and that's missing from this lesson, I apologize. So in reality, a declaration of incompatibility is normally taken on board by the government and they will do something about it, but they don't have to. And also, the important point to make here is that the Supreme Court in the UK has not got rid of one of these laws. They do not have the power to strike down a law that conflicts with the European Convention of Human Rights or the UK Human Rights Act, whichever version you want to use. And remember, those two documents are essentially the same. Just one is in UK law and one is kind of a European system. So that shows a weakness of the UK Supreme Court compared to the US Supreme Court. Now, I'm not saying that the US one is better. This has its own problems. I mean, think about that gun rights law issue. You know, it's not always better to have a Supreme Court that can strike down laws, but it does show a difference in the relative power and the relative superiority and the relative influence of these two different Supreme Courts on the lives of their relative countries. What about the judiciary and the executive? So if we just go back to our little diagram here for a second. So we're talking about the relationship between branches here, and we've just talked here about the judiciary and the legislature, and we've said basically the legislature is stronger than the judiciary. But the problem is, when we talk about this relationship here, executive and judiciary, the UK system is again slightly complicated because we have a fusion of powers. Our executive is in our legislature. As you know, Boris Johnson is an MP and he's a prime minister, unless you're watching this in the future, and then goodness knows who it is. But this is the issue between here. So when we're talking about sometimes the judiciary and the executive, and we're talking about the prime minister, we're talking about people that are also in the legislature, which makes this argument a little bit more complex, rather than saying the judiciary can do this or can't do that or whatever. But so bear that in mind when we're having this conversation, that the fusion of powers makes the UK system more complex to understand, and this relationship more complex to understand. Now, before I go into this thing here, we have discussed this relationship already in class. You hopefully read it. When we talk about things like the Gina Miller case, that is an example where the judiciary was able to smack down the executive and get them to change their mind. The Boris Johnson proroguing Parliament case was another. And in fact, nearly all of the Supreme Court cases we've looked at have some connection to the executive. And it's nearly always the judiciary saying, executive, you have gone too far, you've committed ultra vires, or you can't do that, that's not one of your powers, or you can't do that because that breaks the law, or the other way around, you can do that. That is one of your powers. That is allowed, etc., etc. The judiciary and the executive relationship is far more equally balanced, and in fact maybe even arguably balanced in favour of the judiciary, because the judiciary can make rulings on what the executive can do. The executive can't really go back the other way. However, this relationship has changed over time. So this is perhaps the first important point here, is that this relationship has changed. The judiciary in the UK used to be a very conservative, authoritarian body. You should know it used to be in the House of Lords. They used to be called the Law Lords. It used to very, very rarely get involved in what the government had done. And it very rarely used to make rulings that interfered in government business. And this has changed over probably the course of your lifetime, and certainly over the course of mine. This relationship has changed significantly. Why? Well, there was a huge rise of rights culture in the 1960s. Think about gay rights, disabled rights, ethnic minority rights, women's rights, if I didn't already kind of say that. From the 1960s onwards, huge amounts of legislation was put in place to give equal rights to different demographics in the UK. And this, if people have more rights, then there are more laws that the courts can use to restrict what the executive and indeed the branches of the executive can do. So rights is a big difference. The Human Rights Act 1998, which brought the ECHR, the European Convention on Human Rights, into UK law, was a huge change, because that brought all of these rights, which may have been in UK law or not before, into a single document, a single basically bill of rights for the UK. It's not codified, it's not entrenched. Well, no, maybe it is codified. It is written down, but it's not entrenched. It's not a higher law, but it certainly gives a far more specific guidance as to these are the laws that the Supreme Court should be looking at. Maybe you can have a read of it, maybe, or read like the first couple of pages of it or something like that. I'm sure you can find it online with a quick Google. The creation of the Supreme Court in 2005, which then opened in 2009, was again huge. It separated out the separation of powers. Because remember, the Supreme Court used to be in the House of Lords and now they're not, and that creation of that as a separate building and a separate institution helped to reinforce this idea that they could and should be making rulings to interfere in what the executive did. So it was a cultural change as well as a structural change. And because of that, the judiciary no longer sees itself, reading here, as subordinate to the executive, whereas perhaps they used to. Like if you go back up here, maybe the judiciary used to kind of see themselves as not really their place to intervene. Now they very much do. And of course, the two examples I gave earlier of the Gina Miller case and the Boris Johnson proroguing case have shown very much this new Supreme Court that is willing to say to the Prime Minister, the most powerful person in the country, no, that is not your power. Or no, you must send that through Parliament. So we have seen a huge cultural shift here. So arguably, maybe the executive has become more dominant against the legislature in time, and we'll look at that relationship in our next video. But the judiciary has become a counterbalance to that, an important counterbalance. So even though now perhaps the executive can get laws through the legislature relatively easily, the judiciary has become a more important way of telling the government, no, that breaks the law, that is not your power, and that is unacceptable. So the judiciary is now a very important part of protecting our rights and a very important part of our system. The big asterisk here is, though, that, of course, our executive, as I said earlier, is part of our legislature. So if the judiciary slaps down the executive could propose a new law which would go to the legislature, and if they were to be able to get that law through, then the judiciary would then have to obey that as well. So that complexity of the fusion of powers is part of the complexity of this relationship of the judiciary versus the executive. To kind of simplify out, the executive cannot overrule the judiciary, but the executive can influence the legislature, which can overrule the judiciary. So that shows the importance of the kind of the three-way relationship in British politics. And to go back to our kind of initial slide here, hopefully now you have a better understanding of how the Parliament nearly always overrules the judiciary. The judiciary nearly always overrules the executive, but the executive has the power to influence the legislature, which can influence the judiciary. Do your reading, reinforce this idea, try and understand this relationship. If you have any questions, ask me specific questions and I will do my best to answer them and clarify them. If you like the video, give it a like, subscribe to the channel, all that kind of stuff. And I will see you in the next one when we will be looking at specifically this relationship between executive and legislature, because there is a lot to discuss there. Thanks. Bye.